Good evening, everybody, and welcome to Fox Williams. My name's Steve Sidkin. I'm one of the partners here at Fox Williams, and I chair our agent law team, a team of commercial lawyers and litigators that are involved certainly every week of the year, if not every day of the year, in dealing with issues concerning agency and distributorship agreements when they go right and sometimes when they don't go so right. And it is really good to see all of you here. I can't actually express that too much, given everything that we have gone through over the course of the last 20 months. So welcome, you're all very welcome, and it really is good to see you. So our first speaker tonight is my colleague Emma Roake. Emma's going to be talking about failure to reach sales targets, how terminated agents may be able to strike back at their principals. She's then going to pass over to Lucy Coffey. Lucy's going to be talking about minimum purchase requirements. Can suppliers squeeze out underperforming distributors? And if so, what is the best way of doing so? Then, as a joint presentation, Veronique Bergau and Ellie Wilson-Holt will be talking about do not destroy, the extent of disclosure in litigation and how agency and distribution agreement disputes can be won or lost. And then lastly, I'm going to get out my crystal ball, and I'm going to be talking about controlling sales by distributors, dual pricing and other changes, what's in store for 2022, because there is a lot in store for 2022, I assure you. And Emma, over to you to talk about what happens where there's a failure to reach sales targets. Over to you.
Thanks, Steve. May I echo Steve's comments as well. It's really nice to be able to do this event in person rather than delivering my presentation into the ether in my spare room. So welcome, everybody. This evening I'm going to be talking about sales targets in the context of an agency agreement. So sales targets are usually set at the outset of an agency relationship and then again on a seasonal or a yearly basis. Sometimes the agent will propose the sales targets, especially well-established agents. Sometimes the sales targets will be imposed on the agent by the principal. Whichever way it's done, I think most people will agree that setting sales targets is more of an art than a science. And as with any target, set them too high or too low, and it could be a recipe for resentment and also potentially a source of further future disputes. Agents will usually look at sales targets as something to be aimed for, but they'll be all too aware of the real-life variables that can intervene to prevent those targets becoming a reality, from the loss of a major customer to a poor collection by the principal to something more serious and unexpected, for example, COVID. Principals will usually see sales targets as more of an absolute. They'll see them maybe as a minimum. They'll factor them into their financial planning, and often if the agent looks like they're at risk of missing by a significant margin sales targets, or if they're repeatedly missing sales targets, then the principal's mind is likely to start to turn to the prospect of exiting the agency agreement. So in this presentation, I'm going to be looking at the following. First of all, common provisions that you see in agency agreements relating to sales targets and the consequences of not meeting them. Secondly, I'm going to be looking at the question of whether principals can terminate the agency agreement if an agent fails to achieve the sales targets. And then third, I'm going to be looking at how agents might be able to strike back if they find themselves in the position where their agency contract is terminated as a result of failure to achieve sales targets. If you have a written agency contract, it's likely to say something about sales targets. So common terms in agency contracts include the following: a duty on the agent to achieve the sales targets for a particular season or year, a provision often stating that the principal and the agent will meet at the end of that period, the season or year, to discuss and try to agree targets for the next season or year. There'll often be a schedule to the agreement setting out the sales targets for the first few seasons or the first year at the outset of the relationship. There might be a provision in the agency agreement, if it's been drafted by the principal or principal's lawyers, saying that any failure by the agent to achieve sales targets is automatically a material breach of the agency contract. And the purpose of all these provisions in agency contracts, which will be drafted by principal's lawyers for the most part, is to try to give the principal a remedy if the agent doesn't achieve sales targets, usually to give the principal a right to terminate. That's the purpose. Whether that's the effect remains to be seen. So in written agency contracts, if there is a provision that says the agent must achieve sales targets in a particular season or year, then if the agent doesn't achieve sales targets in that season or year, it will be a breach of contract. But that's only the beginning of the analysis. Just because there's a breach of contract doesn't mean that the principal is entitled to terminate the agreement, and also doesn't mean that if the principal does terminate the agreement, it's let off the hook from paying indemnity or compensation. So in the next two slides, we'll look at two different scenarios where an agent fails to achieve sales targets. In the first scenario, we'll look at the situation where the agency agreement doesn't say anything about the consequences of an agent failing to achieve sales targets. And in the second slide, we'll look at the scenario where the agency contract actually says if the agent fails to achieve sales targets, that will be a material breach of the agency agreement. So in the first scenario, we look at a situation where the agent has failed to achieve sales targets, but the agency contract doesn't address what the consequences of that are. In these situations, principals will often come to us and say, can I terminate the agency contract and avoid paying compensation or indemnity as a result of the agent's failure to hit the target that we agreed on or that was imposed on the agent? And the answer is to be found, in this scenario, is to be found in the regulations. The commercial agents regulations say that the only circumstances in which a principal can terminate an agency contract without paying indemnity or compensation is where the agent has committed a repudiatory breach, and I'll come on to that term in a minute, of the agency contract, and the principal terminates the agency contract because of that breach. So repudiatory breach is something that we've spoken about in previous seminars, and you might think we bang on about quite a bit. Essentially, it means a breach which is so serious that it goes to the heart or the root of the contract. It undermines the whole intention of the arrangement between the parties. It's a high bar to actually meet, but effectively it's something which destroys the commercial agreement between the parties because it's so serious. Although there aren't any reported cases of the English court on this point, generally speaking, a one-off failure by an agent to achieve sales targets is unlikely to constitute a repudiatory breach of the agency contract, unless the failure is so spectacular that it has serious consequences for the principal, or there are other factors in play, and that will usually be other breaches of the agency contract by the agent. You know, for example, the agent's not doing what they're required to do, not complying with reasonable instructions, that sort of thing. So that's the scenario where you have an agency contract which provides the agent has to achieve sales targets, but doesn't say anything about the consequences. There you are, if you're the principal and you want to terminate, you need to show a repudiatory breach. So the second scenario, we'll look at the position where the agent has failed to achieve sales targets. But in this situation, the difference is that the agency contract provides that a failure by the agent to achieve sales targets will be a material breach of the agency contract. So in that situation, what the principal has done is tried to elevate the breach of contract by the agent failing to meet sales targets into a breach which is a material breach, and there'll be another clause in the agency contract which says that the principal can terminate the agency contract as if the agent commits a material breach. So effectively, the principal is trying to elevate that breach to a serious breach so it can terminate the agreement and try to argue that it doesn't owe compensation or an indemnity. So in this situation, if the agent doesn't achieve sales targets, the principal will be able to terminate the agency contract with immediate effect because there is a provision in the agency contract allowing them to do that. However, the key question for the principal and the agent, as is always the key question for principal and agent on the termination of an agency agreement, is the principal let off the hook from paying compensation or indemnity to the agent? Just because they've terminated doesn't mean the principal's still not exposed. This point was addressed in the case by the judge in the case of Crane and Sky, where the judge said that whatever the contract said, in that case the contract provided that particular breaches which would normally be seen as not necessarily serious by the agent were to be seen as automatic material breaches for the purposes of the contract. The judge said that whatever the contract said, the principal could only rely on a breach of contract to avoid paying compensation or indemnity if the breach was, as a matter of law, a repudiatory breach, which brings us back to where we were in the last slide. So whatever the contract tried to do in elevating a more minor breach to a what's called a material breach, the test that the court would apply in determining whether a principal owed compensation or indemnity was the breach repudiatory? Was it sufficiently serious as a matter of law? That said, the clause in that the principal included in the contract saying that a failure to achieve sales targets is a material breach would be helpful to that in that situation to a principal, because the principal could say, well, we've thought about this in the drafting of the contract, and we've said we concluded the intention of the parties was that a failure to reach sales targets was considered by us to be a serious breach. But it it's not an automatic let off the hook for the principal in terms of paying indemnity or compensation. So where does this leave the agent then, whose agency contract's been terminated as a result of a failure to achieve sales targets? Well, it's going to depend if you're the agent. It is possible for an agent's failure to achieve sales targets to be a repudiatory breach. If the agent fails to achieve sales targets by a spectacular margin, and if there are easy comparators, for example, if the principal has 6 agents covering various territories, geographical territories in the UK, one agent spectacularly misses sales targets, all the other 6 agents are either meeting or exceeding or nearly meeting sales targets, then it's easier in those circumstances for the principal to be able to argue that this one agent who's failing to achieve sales targets is in repudiatory breach. So if you're an agent, there's no general rule that failure to meet sales targets can never be a repudiatory breach. It can be. But on the other hand, agents will sometimes come to us and say, well, the principal wanted to exit the relationship and snatched at the fact that I didn't meet sales targets by, I got 80% or 60% or 50%, snatched at that as a reason to terminate when there were no other factors in play. So as an agent, if you feel hard done by, if you feel that you weren't in very serious breach of the contract, then you should be making a claim for compensation or indemnity if your agency contract's been terminated as a result of failure to meet sales targets, unless you know that actually what you did or your failure was a serious breach. And you could also argue as agent that if there is a contractual clause in your written agreement which says that if you fail to meet sales targets, that's automatically a material breach, you can say, no, you have to show that it's repudiatory as a matter of law. It might sound like a strange distinction, but effectively what you're saying in those such circumstances is a principal can't make what isn't a serious breach into a serious breach by just denominating it in the contract as being a serious breach. So finally, there's also open to an agent a claim based on good faith. So the terminated agent should be looking to gather evidence to support its claim for compensation or indemnity if it's been terminated as a result of a failure to achieve sales targets. So one weapon in the agent's arsenal is the fact that the regulations impose on the principal a duty on the principal to act in good faith in its relations with the agent. Now this duty on the principal was totally radical when it was first introduced in the regulations. There is no obligation on the principal as a matter of English common law to act in good faith towards the principal. So this was very new. It's also quite an undeveloped area of law. It's the regulation in which imposes the duty of good faith on principals is often overlooked by principals and agents alike. But it certainly has legs, it certainly has potential, and you could see how an agent who has been terminated, the agent thinks unfairly, for failure to achieve sales targets, might say, well, actually, the duty to act in good faith requires the principal to have acted fairly, with fairness, in the course of the agency agreement. So how could that duty potentially be deployed in a case where an agent has failed to meet sales targets? Well, if you think about it, in most agency relationships, the principal is provided by the agent with weekly, fortnightly, monthly reports saying who the agent has visited, who they've called, who they've shown the collection to. There might be discussions between the agent and principal of which new accounts the agent will be targeting as potential accounts for the next season or the next year. And the agent and principal might discuss the agent's marketing strategy. So if the principal is getting all this information as to what the agent is doing, who is seeing, who it's showing the collection to, and hasn't batted an eyelid, hasn't raised any concerns, hasn't said, I don't think you're seeing the right kind of customers, you're not really seeing enough, you're not showing enough of the collection, or we've had some problems. If the principal isn't raising those sorts of concerns as you go along, you can see how it might be difficult if it came to the end of the particular season or year to say to the agent, you're in repudiatory breach because you haven't achieved sales targets. Because effectively, if the principal hasn't said anything and is aware of what the agent's doing, is aware of what the agent's activities, you could easily see how the agent might say, well, you've tacitly approved my performance, my activities, you haven't said anything about it, you know what I've been doing and who I've been seeing. So you could see in those situations that an agent might say, well, the duty of good faith would oblige you to actually raise those concerns if you were concerned, and as you haven't, then you've tacitly approved it. So it's just some ideas from an agent, and it's not just confined the duty of good faith to have I if I fail to meet sales targets, can I invoke that argument? It's across the board, and just sort of for the sake of completeness, an agent obviously does owe a duty of good faith to the principal as well, so it does work both ways. Thank you for that. I'm now going to hand over to Lucy, who's going to talk about underperforming distributors.
So I'm going to talk today about minimum purchase requirements and how they can be used in terms of terminating and performance managing underperforming distributors. So what are minimum purchasing requirements? They're obligations that are in distribution agreements that oblige the distributor to make a certain amount of purchases from the supplier. The idea is to ensure that the supplier is making a certain amount of sales in any given territory and to provide the supplier with a tool to manage the distributor. Distributors are appointed generally over geographic territories or to certain customer groups to sell to customers. And if the distributor isn't selling to customers, it's not buying from the supplier. And that failure by the distributor to sell a sufficient quantity of product defeats the object of having appointed the distributor in the first place. So minimum purchasing requirements are included in agreements in two ways. The first is with reference to the value, and that's the value of the products that are subject of orders placed by the distributor and then accepted and fulfilled by suppliers. And the second is with reference to quantity, so that is the quantity of products that are the subject of orders placed by the distributor and then accepted and fulfilled by the supplier. What suppliers and distributors will prefer does depend industry to industry. However, on a very general kind of basis, the supplier will prefer minimum purchasing requirements to be with reference to value. And that's because it provides for a more precise measurement of performance. And that's particularly the case where perhaps the products in the range differ in price. In contrast, a distributor will prefer to have minimum purchasing requirements to be with reference to quantity. And that's because it provides flexibility. It provides the distributor to be able to select or cherry pick certain well-performing product. However, of course, that does cause an issue sometimes to arise in respect of range. So suppliers might expect for there to be a certain amount of range on the market that the distributor isn't providing. So in terms of minimum purchasing requirements and reliability and the use in contracts and then in day-to-day performance management with distributors, whether they are kind of something that can be relied on will depend on what's agreed. So whether that's agreed in formal written distribution agreements or perhaps informal unwritten distribution agreements via emails, conduct, meetings, things like that. It all will depend on what is agreed or what is understood by the parties. A more formal written distribution agreement, you'd think, would generally provide for a clear way forward. However, poorly drafted or incomplete minimum purchasing requirements can cause more of a headache than you might think. Uncertainty will always give rise to a risk of a dispute. That's the case throughout commercial contracts, and it's important to make sure that the minimum purchasing requirements are clearly set out in your agreement. The consequences of failure to meet those requirements are clearly set out in the agreement, and that those consequences are adequate when it comes to rely on them. Often formal written distribution agreements are somewhat half complete. So perhaps a minimum purchasing requirement is included for years 1, 2, and 3, but then the agreement is either silent as to what happens after that point, or something is included that says the parties will meet to agree the kind of years 4, 5, 6 at a later date. And that's understandable. For a supplier to look over the horizon to such an extent can be difficult, especially in the early stages of the relationship. However, that idea of meeting at a later stage to agree is an agreement to agree, which under English law is unenforceable. So if you wanted to rely on that to cause your counterparty to meet with you to discuss future requirements, that's not something that you could force them to do. So this particular scenario highlights the importance of thinking about what's happening later down the line in terms of requirements. And understandably, where requirements can't be set for the whole duration of the term or the expected term of the agreement, you might wish to consider including something along the lines of where the parties can't agree, the minimum purchasing requirements increase with reference to a percentage, or perhaps with reference to an increase in an index. So how about terminating underperforming distributors in terms of not meeting minimum purchasing requirements? Even where minimum purchasing requirements are included, as I said, the consequences need to be clearly and set out in a certain manner and be adequate for the circumstances that arise. And you might ask, in a distributor-supplier relationship, why would you want to look at minimum purchasing requirements? Why not just give notice? You don't have the same concerns that Emma was mentioning in terms of compensation, indemnity in the UK. Well, distribution agreements are relational in nature. There's often huge investment by the distributor at the very early stages, and as such, notice periods tend to be on the longer side of things for commercial contracts. So perhaps you're looking at something like 6, 9, or 12 months. And for a supplier that's party to a distribution agreement with a distributor underperforming, it's unlikely the supplier is going to want to hang around for that period of time. So what does termination look like? In the termination clause for written distribution agreements, the most ideal situation for a supplier will be an immediate right to terminate when minimum purchasing requirements are not met. It's an absolute right, it's binary, either the requirements are met and there's no termination right, or they're not met and there's a termination right. So one strike and you're out approach, and it's unlikely to be acceptable to a distributor unless you are dealing with a supplier in a very strong position. So what else could be relevant? Perhaps there's an immediate right to terminate when the distributor fails to meet the requirements over a certain period of time. Perhaps this is with reference to quarters or kind of on a half-yearly basis. A less favourable option is the material breach option that Emma mentioned, and that's the idea of having to show that the materiality threshold has been met to call a termination event is a risk, because if you get it wrong, you're likely to be on the receiving end of a damages claim for damages in lieu of failure to give proper notice. Other than termination, it is possible for a supplier to provide that the distributor is to pay the difference, so between the purchases made and the minimum purchasing requirement. This is a type of liquidated damage, and therefore you have to be careful that it's not so ridiculous, disproportionate, unreasonable in terms of what you're actually trying to protect for the sales in that territory as to be a penalty, because the penalty under English law, again, is unenforceable. It's a bit of a case of be careful what you wish for. Another option would be to change the grant, so change the distribution grant. So perhaps you might take away some of the territory, perhaps you provide for some of the customers to be taken in-house to the supplier, or the distribution arrangement, if it's exclusive, maybe you decide to change it to a non-exclusive distributorship. The issue with that is if you have a non-exclusive distributor in place, you can only ever appoint another non-exclusive distributor, which can be unattractive. For unwritten agreements, consideration should be given to whether the failure by the distributor is such that it provides for a failure of performance. Failure of performance to the most severe degree would provide for a failure of consideration, and without consideration there's no valid contract, so the contract would not exist. Whether operating under a formal written distribution agreement or an informal unwritten distribution agreement, what is important is a paper trail, and that's something that Veronique and Ellie will touch on, but a supplier will want to have to hand evidence of underperformance, and likely the distributor will likely want to point to evidence where the supplier has given the okay to underperformance. So be careful in terms of being able to use the right, what might come back at you. It's also one of those situations where it's lose it if you don't use it. So if you have a right that's triggered under a contract in terms of minimum purchasing requirements, look to use it within a reasonable time. And then finally, just in terms of other considerations with minimum purchasing requirements. The first is where the effect of the minimum purchasing requirement on the distributor is such that the total purchases that it makes ensures that 80% of those total purchases are from the supplier, it will amount to a non-compete. Under English and EU law, as a competition law point, those non-competes have to be limited to 5 years, or the term of the agreement if it's less. Generally, volume commitments can cause an effect on the market and trigger competition concerns. Consumers effectively can have less choice as to where to buy product. However, in a distribution arrangement, it's unlikely to trigger serious concerns. A distribution agreement will often fall within a vertical block exemption regulation, which is something I think Steve might touch on. So termination is a severe step. You do need to make sure that you have everything lined up before you terminate, so as to ensure that smooth transition to the next stage. If you have a replacement distributor in the wings, if you're operating under an exclusive distributorship, don't appoint that exclusive distributor in replacement until termination has taken effect. And that's not whilst notice is running, it's when notice has expired. Otherwise, you're committing a serious breach of your distribution agreement. You should be thinking about stock. So have there been orders placed by the distributor, accepted by the supplier, only then for the distribution agreement to terminate? Do you have to fulfill those orders? And if you do, what terms is the distributor under in terms of selling those products on to its customers? For unwritten distribution agreements, there's likely to be an implied license in terms of being able to use the trademark to continue selling within the territory. You should have a look at your distribution agreements to see what's said about selling stock back to the supplier, or perhaps selling to your newly appointed distributor. Perhaps there's a handover period that's provided. It's all things to be thinking about. In addition to cost, who's going to be paying for kind of transfer of stock and things like that. And the final point is that the distributor might be holding stock it's not yet paid for. That's a common issue that we kind of advise on regularly in terms of how do you get your stock back. And really what that turns on is your written distribution agreement, your written terms and conditions of sale. One of those two or both might have retention of title provisions, and they're really important. Without retention of title, it's unlikely you're going to get that stock back. The distributor might take issue with the fact that you've terminated the way that you have and say that it's going to set off liabilities and keep that stock, the liability that you owe it for your termination of the distribution agreement. Retention of title means that until payment's made in full by the distributor, the supplier owns the stock, even though it's with the distributor or perhaps a third-party warehouse. And that's particularly important when you're dealing with administrators who are kind of in control of the stock. You need to be able to have that piece of paper that shows your retention of title claim. So that's everything I wanted to cover today in terms of minimum purchasing requirements, and I will hand over to Veronique and Ellie in terms of disclosure.
First of all, thanks Lucy for the introduction, and welcome everyone. It's lovely to see you all here today. So up on the slide, you'll see the 5 topics that we'll be talking about today. We're starting with what disclosure actually is, then when you will need to do it, how you can best prepare yourself for disclosure, whether it's possible to withhold documents, and finally our top tips, which will hopefully make your life easier in the event that you find yourself involved in litigation. So, what is disclosure? If you're a party to English court proceedings, the way that you prove your case or tell your story is either through witness evidence, so written statements and then cross-examination at trial, or through disclosure of documents. Both can impact whether a party wins or loses, but in our experience, judges are usually pretty heavily guided by disclosure because a document obviously says what it says. And this makes disclosure an extremely important part of the litigation process. So as you'll see from the slide, there are actually 2 different elements to disclosure. The first part is the stating that a document exists, which is normally in the form of a written list, which will be prepared by your lawyers. And the second part, which is probably what people most likely think of when they think of disclosure, is the handing over those documents to another party for them to inspect. As I'm sure you're aware, the entire disclosure process can be pretty costly and pretty time-consuming. The initial document gathering process will require a lot of input from you as the client, particularly in relation to a search for relevant documents. We as lawyers then review those documents for relevance and privilege and produce the list that I just spoke about.
Now, because it's such an important part of the litigation process, whilst it's true that it is costly and it is time-consuming, the outcome of a case very often turns on the documents. So many cases settle shortly before the disclosure stage or shortly thereafter.
So, when will you need to give disclosure? Well, it used to be that you didn't have to think too much about disclosure until fairly far down the line of the proceedings, after you've had your first, after the parties have set out their legal case and you've had your first procedural hearing. But in January 2019, a new pilot scheme was introduced, which is still ongoing and applies to most of the cases in the business and property courts and the High Court where we tend to act. And this requires the parties to engage a lot more closely right from the outset. So as soon as you know that you're going to be a party to proceedings, you need to preserve all documents. That, in fact, isn't new, but the obligations, the practical steps that you need to take have become a little bit more onerous. So you need to suspend any document destruction processes, and then you also need to write to any third parties that might be holding documents on your behalf. So that could be subsidiary companies, it could be accountants, to expressly ask them not to destroy any documents that might be relevant to the dispute. Then a little bit further down the line, as you're preparing your pleadings, so if you're the claimant, your claim, if you're the defendant, your defence, you need to, when you file those documents, provide copies of all the key documents that you've relied on to prepare the case, and those documents that you believe your opponent needs to see in order to understand your pleading. So that's initial disclosure, and then we get to extended disclosure a little bit further down the line, and that's the fun bit for us, where we can start being a bit more creative in terms of thinking about what documents might your opponent have. So we're looking at the facts of the case, we're looking at the legal arguments, and we're going to try and drill down and hopefully ask some clever questions from the other side and ask them to produce documents that both will help prove our case and disprove their case. But it doesn't end there. There's an ongoing duty to disclose. So if at any point of the proceedings you find a document that's relevant to the case, you do need to disclose it.
It's important to make clear at the outset that a document can take many forms. It's not just A4 pieces of paper, it's not just emails, it's also things like WhatsApps, Slack or Teams messages, Instagram messages, or things like calendar invitations. Basically, if information is capable of being recorded on it, it is possible that it's a document. And it also includes things like deleted items, metadata, embedded data. Veronique just mentioned the need to halt document destruction systems in the event that litigation is reasonably in prospect or has begun, and this extends to changing or altering or tampering with the document's metadata. So looking at the third bullet point, the documents must be within your control. Now, this is not as narrow as you might think it is. A document would still be in your control if it was held by a subsidiary or by a third party from whom you can normally request documents in the ordinary course of business. So if it can normally be retrieved by you or requested by you, it's in your control. So the pilot scheme, which applies to most cases we work on, involves 5 different types or models of disclosure, which I'm not going to go into here. But no matter what the model, you will be required to disclose documents which both support and undermine your case. We'll talk later about withholding documents, but as a bit of a spoiler, you can't do it simply because you've got a document that makes your case look bad. And something to bear in mind is that people don't typically tend to write emails or draft documents thinking that random people might one day read them, particularly not a High Court judge. And I've certainly seen some pretty colourful things in the course of document review, my favourite of which was a man who was very obviously having an affair with 3 different women in the office. But the point is that it's advisable to always think very carefully when writing emails and other documents, particularly if you're a principal intending to terminate your relationship with an agent or a supplier in your dealings with a distributor or vice versa.
So how can you best prepare yourself for disclosure? Well, of course, it's difficult to predict what the issues might be later down the line if you do find yourself in a dispute. But there are a few general guidelines that we think that everyone can follow that will help during the course of your agency or distributorship relationship that should stand you in good stead should you later down the line find yourself in a dispute and faced with a disclosure exercise. So when parties fall out, the first thing we'll always look to, of course, is the commercial relationship. Sometimes that's all set out neatly in a single document and we can have a look at the terms and try and interpret them. Other times they'll be set out in a course of correspondence. Separate agreements might have been agreed orally, and then we might be looking at documents that help us to show a course of dealings. But we certainly find that, and as Lucy's already touched on, the more certainty we can have in terms of written documents, the more that's going to benefit us down the line. Therefore, keeping a paper trail becomes really, really helpful, particularly when you sense that the relationship is turning sour. Couple of tips to be aware of. Commercial agents, Regulation 12 of the Agents Regulations, oblige principals to provide commission information to their agents. So if you're an agent and you think you might be owed unpaid commission, write to your principal and seek that information. Similarly, principals who have concerns about an agent's performance, keep a record of your complaints that you've communicated to your agent, any responses that you've received. If targets have been communicated, make sure that they're in writing. Conversely, if you're an agent and you've received complaints, keep a really clear record of the efforts that you've made, the meetings you've gone to, so you've got this neat file of documents in an ideal world that we can turn to later down the line. Distributors, you might be suspecting, for example, that others are supplying in your territory. Perhaps alarm bells are ringing because your supplier's been asking about your customer base. Ask questions in writing. Why do you want this information? And if you receive vague responses, press them on it, try and get as much down on paper as you can. Be forensic in your approach, it will pay off later down the line. And then, of course, if a relationship's come to an end, ensure that you've got a really clear paper trail to demonstrate that you're terminating the relationship in accordance with the agreement. Principles, that becomes a little bit more complex. You also need to start, of course, thinking about the agent's regulations. The regulations provide for minimum notice periods. So are you meeting those minimum notice periods, or does the agreement provide for a shorter period? And then you could find yourself in a bit of trouble later down the line. And of course I would say this, but if any doubt, come and get some advice.
So, topic 4, can you withhold documents? And the answer is yes, you absolutely can, as long as that document is privileged. So what are privileged documents? Very, very high level overview. There are different types of privilege, but the main ones to remember for these purposes are legal advice privilege, which exists when there are confidential communications between a lawyer and a client, the dominant purpose for which is the giving and receiving of legal advice, and litigation privilege, which protects documents created confidentially for the dominant purpose of pending, reasonably contemplated or existing litigation to which the client is or may be a party. But it's our job to review the documents for privilege and advise you which ones are or which ones are not. A key thing to note is that you do still have to disclose the existence of privileged documents. It's just then the other side will be prevented from inspecting them. So what about commercially sensitive or confidential documents? Well, unfortunately, your duty to disclose trumps any duty of confidentiality. However, if part of the document is commercially sensitive and irrelevant to the issues in the case, then it may be possible to redact it, either certain paragraphs or pages. So what would happen if you don't comply with your disclosure obligations and you withhold non-privileged relevant documents? So firstly, there could be cost sanctions. Secondly, the court could draw adverse inferences as to the content of those documents. So it would assume the worst case scenario for you. Or you could be found in contempt of court, which carries a prison sentence of up to 2 years. Realistically, that's unlikely to happen, and the punishment probably won't be that severe, but it's still important to be aware of the very serious consequences of non-disclosure. And finally, what do you do if you think your opponent is withholding documents? Well, in these circumstances, we can make an application for something called specific disclosure, which is when you apply to the court for an order compelling another party to disclose either certain documents or a category of documents. And if you're successful in any such application, then you should be able to retrieve a pretty hefty portion of your costs.
So I will round off with our top tips. I think we've hammered home that keeping a paper trail is absolutely key. Please ensure all your key communications are recorded in writing. Please also think carefully before creating a new document. Will it help or hinder you later down the line? How will it be perceived by a judge? And of course, it's even more important to tread carefully when you are terminating a relationship. And finally, please don't tamper with or destroy documents. That includes metadata. We've seen all sorts of creative things be done with documents, but forensic analysts, IT people can, go back and perhaps question the date of a document. So it's far better for us to be able to attach a narrative to a document, to explain it, than to have to explain to a High Court judge why it's been destroyed or amended in suspicious circumstances. So on that note, we will pass over to Steve.
Just before I move forward with what suppliers and distributors can expect in 2022, let me echo a couple of things that Veronique and Ellie touched on. It is the case, in fact I remember it very vividly, about 4 or 5 years ago, Emma and I were acting for a client. The client was in the process of parting company with its agent, and one of the issues we had to consider was the passing of WhatsApp messages between the parties. The passing of WhatsApp messages included the passing, if I remember correctly, of images that called into question whether certain criminal offences had been committed. So please, if you're going to be exchanging messages of any type, whether it's emails, whether it is WhatsApp messages, whether it's text, anything at all, with other parties, do be aware that ultimately they can see the light of day and have consequences. And the other thing, just to touch very briefly on it, I echo very much what Ellie and Veronique have said. Please never do an Enron. In the United States, the destruction of documents by Enron ultimately led to the end of Arthur Andersen in the United States. And we don't want the same sort of thing ever to happen to any of you. So please, don't do an Enron. Right, we come to the art of the possible. The art of the possible. Why? It is the case that there are various things that various parties would like to do, whether we're talking price stability, which is arguably a euphemism for resale price maintenance, restricting territories in which third parties can sell, dual pricing, having one price for goods going into store, one price for goods going online, restricting the use of marketplaces and platforms. One thinks of Amazon. All of these are issues that we come across because we're asked to look at them, or whether it's for brands that we act for, whether it's for third parties acting for brands. And it is the art of the possible. Why? Because ultimately, whether clients choose to be bound by what the law says, or whether they say, well, we can possibly get away with it, is an issue for them. Within the law, we talk, as lawyers do, about hardcore and softcore restrictions. I may use those terms going forward. Hardcore restrictions, if there is something that is a hardcore restriction, and you do put that sort of restriction in your agreement, or perhaps seek to impose it outside of the agreement, then there are going to be consequences. The agreement is going to come to an end. Softcore restrictions. Softcore is when the restriction itself fails, but the agreement nevertheless continues. So that's a bit of a spoiler alert. But why the need to comply with competition law or UK and EU competition law at all? Well, it's because if you don't and you cross the line and your restrictions mean that you are infringing UK or EU competition law, there will be consequences. The agreement itself can be ended, just ends. There can be consequences in terms of third parties claiming damages against you. There can be consequences under English law of penalties being imposed on directors and senior managers involved in the infringement. Those penalties can be monetary, they can also be penal, and we have seen directors and senior managers be imprisoned as a result of infringing competition law, as well as, in the case of directors, being banned from being directors for a period of time after the offence has been committed. And both under EU and UK competition law, fines can be imposed, whether it's by the EU Commission or whether it's by the UK's Competition and Markets Authority. So there is a need to comply. That need exists today. It's going to exist in the future. But, in the words of Bob Dylan, the law, it is a-changin'. And the law, it is a-changin' because the current law that we have, so far as the UK is concerned, which is a mixture of EU law and UK competition law, that is in existence now through to 31 May 2022. On 1 June 2022, we will have new law. It's changing because of Brexit. It's changing because of the decisions that were taken in 2016 and since then, with the result that we have a somewhat strange situation that the law that existed up until January of last year is called EU retained law, and that continues to apply so far as the UK is concerned. And the current EU competition law is part of that retained law. So that will continue through to 31 May 2022. We have the law, it is a-changing because there are different channels to market. When the existing EU competition law was drafted back in plus minus 2010, we didn't have, or certainly we didn't have to the same degree as we have today, the use of third-party platforms. Amazon, yes, it was a force in the marketplace, but it was nothing as it is today. So there have been changes in the channels to market. The law, it is a-changing. And we have also a recognition by the competition authorities, by the EU Commission and by the CMA in the UK, that there can be vertical supply chains which cross over into what are effectively horizontal agreements. So a vertical supply chain typically in the classical sense would involve a manufacturer selling to a wholesaler who sells to a retailer who sells to a consumer. But now we see manufacturers selling direct to consumers, but also selling on to wholesalers who will perhaps also sell direct to consumers, as well as selling to retailers who definitely will sell to consumers. And where there is the same parties selling to the same base customer, whether it is at the wholesale, retail or consumer end, we're into horizontal agreement territory. And given that EU and UK competition law in this area is primarily concerned with vertical agreements, there's a bit of a mismatch, which both the EU Commission and the CMA have had to come to terms with. So let's just touch very briefly in the next slide about exclusive distribution and selective distribution. Exclusive distribution is my appointing Emma and Emma being able to sell my products within a given territory to the exclusion, note the words, of all others. Is there a law that actually says that? Well, not quite. And therefore, as lawyers, we invariably look at other words in the agreement which may or may not detract from the exclusivity which I have granted to Emma. That's the current position. But what we see is that the European Commission is now talking in the notes that have been published by the EU Commission about there being a limited number of exclusive distributors, which calls into question how you can have a limited number of exclusive distributors given the very meaning of the word exclusivity. Part of my darker thoughts will probably say that this is almost akin to the announcement made about a year ago by, I think, the then Northern Ireland Secretary, who, when the UK Parliament was considering the UK Internal Markets Bill, as was talking about the bill breaching the agreement which had been reached with the EU in a specific and limited way. So we'll have a limited number of exclusive distributors. But what's the CMA's position on that? We don't actually know at the present time. Are they edging towards that? Not sure. And what about passing restrictions down the supply chain? The EU Commission seems to be fine going forwards, come 1 June 2022, that will be possible. I know for a fact, given some of the requests we've had over the last few months from our clients, that they're going to actually be very appreciative of the ability to pass restrictions down the supply chain. Again, the CMA's position is up in the air at the moment. What about selective distribution? Well, selective distribution is where goods are supplied on the basis that if a particular party, the next level down in the supply chain, is able to meet certain objective criteria, then they are able to be admitted or are required to be admitted to the club in order to be a distributor of that particular product. Selective distribution is effectively an escape mechanism for certain products, or certain goods, certain brands, from the restrictions that would otherwise be required by EU and UK competition law. What I think we're going to see is a movement there as well, which is going to help brands, but we shall see. So if I can move you on, please, then to the next slide. And I'm going to talk about online sales restrictions. And it is the case that both the CMA, the Competition and Markets Authority, and the European Commission are contemplating a relaxation of the treatment of online sales restrictions. So where previously online sales restrictions were regarded as hardcore, were regarded as if you put them into your agreements, there would be a problem, there would be an infringement of competition law. It looks as if they're going to be allowed in very broad terms. And why? Because the online channel has now become so well established, arguably so well established, as we'll see in a moment, that the in-store channel needs to be protected. And in terms of protection, well, part of that protection comes in the form of the concept of dual pricing. And I think where we are is that the EU Commission is now taking the view that provided dual pricing rewards an appropriate level of investment, there can be one price for in-store and one price for online. Certainly the CMA sees no problem with this at all, and I think where we will end up is that the EU Commission will be in the same position itself. And similarly, the Commission and the CMA take a view that different criteria can be used outside of the pricing concept. Different criteria can be used for both in-store and online sales as from 1 June. What about restricting use of price comparison or paid referencing? That for the EU Commission will be a problem. It will still be a hardcore restriction. The CMA, still to express a view. What about restriction of different languages? The EU Commission's position is that if translating a website into a language not commonly used in the country of the distributor, that is active selling. You're going after a particular market because you translated the website language into a language which is not used in that territory. Active selling can be restricted, so hopefully we will find that that is okay. And the CMA, well, the CMA's a bit behind the EU Commission and still to express a view on that. And different online sales strategies. The EU Commission again is okay. The CMA is going to be publishing further guidance as to whether it's going to treat this, having different online sales strategies, as active selling or passive selling. The difference being that a restriction on active selling is a prohibition, can be prohibited, a restriction on passive selling is going to be an infringement of competition law. And we also come here to the interaction of the concept of the horizontal agreements. If you're selling yourself online to a particular customer base, for example consumers, and you allow the next person down, the wholesaler for example, to sell online to consumers, then that is effectively a horizontal agreement. And as I said before, the law that we have in this area, which is concerned with vertical supply chains, has the difficulty in coming to terms with horizontal agreements. We'll talk a little bit more about that in a short while, but if I can move you on to the concept of dual distribution on the next slide. Dual distribution, if we take the example of where the manufacturer both wholesales and retails a brand, that is dual distribution. The Commission at the moment is saying that where there is a market share of 10% or less, then there can be dual distribution and there will be no question, there won't be any infringement of competition law. The difficulty that lawyers have with that concept of 10% market share is, well, how do we know what the relevant market is? So, if for example we're talking about watches, is the relevant market all watches? Is it watches of a particular type, for example sports watches? Is it watches at a particular price point? What is the relevant market? And that is always an issue for lawyers in this area. But what is of concern to the Commission is where we move above the 10% market share up to 30%, and there is the exchange of information between the parties who are parties to that agreement. It could almost be said, given the news at the weekend, that Et2 JD Sports, given what perhaps happened or didn't happen in a car park near Bury. And then we come to the CMA's view, and the CMA says, well, if there's going to be exchanging information, we're actually quite relaxed about that. It's quite a divergence from the way the European Commission is looking at things. And at the moment, the CMA is saying is we're not going to worry if it's 10%, not 10%, whether it's 25%. What we're concerned about is giving the parties the right to undertake their own assessment. So there's going to be self-assessment as to whether or not the agreement that you have entered into for the purposes of dual distribution does cause a problem or doesn't cause a problem. And the issue, the danger with self-assessment is that you get it wrong. That's the danger. The bigger danger for us as lawyers is that we get it wrong. But hey, someone's got to take the risk. So we have there the interaction of horizontal agreements again, and we have there the problems that arise because what we're talking about is a vertical law trying to interact with a horizontal situation. If I can move you on to MFNs, most favoured nation clauses. Most favoured nation clauses arise so far as the online channel is concerned. Parties are concerned that if they're going to be offering your goods for sale, that you're not going to give a better deal to someone else, to one of their competitors. The CMA is looking to distinguish between a narrow most favoured nation clauses from what it calls are wide most favoured nation clauses. And I hope after this session that you're not going to ask me to try and distinguish between the two. What is the position, however, is that at the moment the Competition and Markets Authority believes that narrow most favoured nation clauses can be allowed, whereas with wide most favoured nation clauses the CMA takes the view that these should be hardcore restrictions. If you put them into your agreement, the agreement itself will fail. So, that's the position of the CMA. It is taking, again, a divergent view from the European Commission. And the European Commission, well, we will see where we end up. As I said before, the European Commission is further down the road in terms of where it wants to be so far as 1 June next year is concerned, and it will be a case of whether the CMA is able to play catch-up. So let me turn now to the final slide, which is the slide of take-home points. So there is still time for change. To adopt the words of, I think, Michel Barnier a couple of years ago, nothing is agreed until everything is agreed. So far as there is still time to change, point 2. Well, what we are seeing, and we have seen certainly during the course of this autumn, is increasing, what I can only describe as increasing political interference with the workings of competition law. We've seen that recently in the supply of carbon dioxide, where competition law has been suspended. Previously we saw that in respect of the supply of motor fuel, petrol, diesel, where again where competition law was suspended. The CMA, the decision by the government, I think it was last year, not to allow an extension of competition law, which was being sought by the then Director General of the CMA, led to his resignation. But the point that I think is really material here is what is going to happen. We're going to be in a situation come the end of May next year that the old law effectively has stopped. It's in a form of suspense, because there will be a transition period to allow for a change from the old law, where the agreements hopefully comply with the old law, to where they will comply with the new law. But for those of you who are in existing agreements, and those agreements do comply with the law as it is, do you stick and be in a situation where perhaps you don't take advantages of what the new law has to offer you, depending on the opportunities which the new law has to offer you? Do you seek to engage in variation? Variation itself, it has to be a consensual process. Both you and the other party to the agreement have to agree on it. Do you terminate the agreement and seek to put in place a new agreement? You can do that, but again, there are risks involved, because your counterparty may say, well, you haven't terminated the agreement in accordance with its terms. Here's my claim for damages. In the concept of the agency relationship, here's my claim for compensation. Or you may find yourself that you terminate the agreement, hoping to put in place an agreement which does take advantage of the opportunities offered by the new laws, and find that your counterparty doesn't want to enter into a new agreement with you. Be careful again what you wish for. And then we come to 2 further issues which will, I'm sure, cause problems. And I say that not because I would like them to cause problems, but because of what they are. It is the case that for many businesses, they will operate in the UK and they will operate in the European Union. Those businesses will have to comply with 2 sets of laws which will differ in some respects. Of that, I'm pretty confident. The CMA and the EU Commission are too far down their process in the new laws that will come into force come 1 June next year, that there will not be differences between them. And businesses operating in the UK and in the EU will have to comply with 2 different sets of laws. And for those businesses trading in Northern Ireland, good luck. Really good luck. We don't know yet what is going to happen so far as the Northern Ireland Protocol is concerned. We don't know if there's going to be a change to the Northern Ireland Protocol. We don't know if there's going to be an invoking by the UK government of Article 16. We are in a bit of a mess so far as Northern Ireland is concerned, but where there is a mess, there will also be opportunities for business, and so who knows where Northern Ireland itself will end up. And with that, on that happy note, I'll close the formal part of the session, but please join me in thanking our speakers.